Good day to you all. My name is Frank T. Hart, lawyer in Amsterdam, and I'm going to talk you through some main topics with regard to MiFID II. I have 3 items for you. First of all, highlighting the AFM and DNB supervisory teams. I'm going to talk you through the MiFID II quick fix regulation. And finally, I'm going to tell you something about duty of care and the difference between providing information to your clients and advising your clients. Let's start with the supervisory teams. Very short, first of all, DNB, 3 items. The first one is more about data-driven supervision. Data-driven supervision is not so much about compliance, but it enables the DNB, but also the AFM, to identify risk in a very early stage. Secondly, sustainability. I will come back to that because that's also an item of the AFM. It's all on our agendas. Finally, the third item, that is combating economic and financial crime. Since July 2018, the implementation of the 4th ALM directive, investigations of DNB and AFM have been increased rapidly, and we all have to do our duty in order to act as a poortwachter, as we say that in the Netherlands. And it applies on all financial institutions, but also on lawyers like myself. Then the AFM. First of all, the priorities, then I'm going to focus on some themes of the AFM for this year, 2021. And I'm talking at the end of June. First of all, financial services. The protection of consumers in vulnerable situations is one of the main topics for the AFM. And they are focusing very much on the product governance and on the duty of care, nazorg, during the services provided to the client. So not so much about the pre-contractual phase, but more in the contractual phase of the relationship with the client. Then secondly, capital markets. The AFM is going to focus more on misinformation. Rules are not changing, but the AFM is announcing that it will apply stricter action when there is a breach of information duties. So that are the main topics. Then to asset management, third topic I want to discuss, one of the AFM priorities, and I will pick 2 of the sub items of it. First of all, they announced that they want to help parties, market parties, asset managers, to implement the cross-border distribution directive, the investment firms directive, and the pan-European pension funds products directive. Then on the other hand, the AFM is also focusing on culture and the compliance function. So those are a few of the sub-items that the AFM has announced as a priority. Then the themes. Of course, sustainability is one of the key issues for all financial companies, not only in the Netherlands, but in the whole of Europe and actually worldwide. And when it comes down to asset managers, the AFM wants to ensure that the asset managers integrate risk related to sustainability into the business operation. Then the second theme is the anti-money laundering regulation. On the one hand, the AFM is also announcing, like DNB, to make more use of data-driven information. So they want to identify in an early stage what the risk profile is of an asset manager, and based on that risk profile, they may select to an asset manager and conduct an on-site investigation with respect to that asset manager. Then the duty of care, which is the second item I would like to discuss with you. Information requirements, investment advice requirements, and difference and pitfalls is what I want to go through. First of all, let's start with MiFID, Know Your Client. Know Your Client as a result of the first MiFID directive in 2007, is part of the daily business and part of the duty of care, one of the main obligations when it comes down to the duty of care. And we all know that we have to gather information about the financial position, the investment objectives of the client, the risk appetite or risk profile, as you may call it, and finally knowledge and experience. But new to that is the non-financial information you have to gather about, from your client about the client, and that are the sustainability preferences of the client. And that makes it, of course, a little bit difficult because especially when it comes down to retail clients, they may not have determined yet for themselves what their preferences are. So I predict that perhaps less professional parties and retail clients may want to be helped identifying what their preferences are. So it's not about the question, do you want to invest in a sustainability goal, but helping your clients to identify what exact sustainability goal that may be. And the United Nations goals, those 17 goals, may help you further with that. So that has to be included. It applies on all type of clients. So that is really something new which will become more important nowadays. Relevant is also when you provide investment advice is that you make clear what the sustainability factors are that you have taken into consideration when selecting the financial instruments. So most investment firms have a range of financial instruments, funds, shares, bonds or whatsoever to invest in, and they focus on those type selected financial instruments. But you have to make sure that you know about each instrument that you are going to distribute, what the sustainability factors are, in order to, and that is also part of product governance, that you make sure that the sustainability factors match with the sustainability preferences of your clients. Is there a difference between information and providing advice? Yes, there is. And for two reasons this is important. Asset managers, vermogensbeheerders, are qualified under SFDR as a financial market party. So that means that they are subject to severe information requirements. On the other hand, if you provide solely investment advice, you are subject to less severe information requirements. And finally, when you're not advising execution only, from a strict legal point of view, that falls out of the scope of SFDR. So in practice, it is important to know exactly what the difference is between providing information to clients and providing advice to clients. And to keep it very short, I will go through the criteria. Is when you provide information, you have to ensure that you provide factual information. So don't qualify facts, but stick to the facts and simply tell the facts. Advice is being regarded as a personal recommendation with respect to a concrete financial instrument. So to keep it very short, it has to be a personal recommendation and it has to apply on a concrete financial instrument. If you advise on an asset allocation, that would qualify as advice under civil law, but under MiFID II, under the BFD, that would not qualify as advice because it doesn't relate to a concrete financial instrument. On the other hand, if you say you have to invest in this fund, or I would recommend you this share or that bond, that typically would qualify as an advice under MiFID II. And CSER, nowadays ESMA, has formulated 5 criteria, which you see here on the sheet, in order to give you some guidance when a recommendation or information qualifies as an advice. And you need to fulfill all 5 in order to qualify the information you provide as an investment advice under MiFID II. If there's no hit on one of those 5, then it does not qualify as an advice. That is it very short. But in practice I say always, is it a personal recommendation, so one-on-one, so not on the website, not when it's made public, then it is an investment advice and it has to relate to a concrete financial instrument. CSR published some further guidance pointing out some pitfalls. For instance, if you discuss with an execution-only client about the investment he intends to do, that may be interpreted by the client as an advice. For instance, if the client asks the investment firm, what do other clients of you intend to do? Those are typically questions which you should deny in a way that you have to say, I cannot answer that because I don't provide you advice, because that may be construed as an investment advice under MiFID II. Other examples of pitfalls pointed out by CSR is a person who may offer to tell a client when certain shares reach a certain value on the basis of a prior recommendation. So stay away from those pitfalls and make sure that if you don't intend to provide investment advice, that you stick to factual information. Factual information. What is the price of the share? What is the price of the bond? What are the characteristics of a fund? Those items, this kind of information, qualifies as factual information and not as investment advice. Here are some more examples: company news, announcements, explanation of terms and conditions of an investment. All examples of factual information. The AFM, as you might have seen, has published an interpretation with respect to investment advice or portfolio management, which has more or less the same meaning. In essence, the AFM is of the opinion that, to put it very short, if you consult your client before making a decision, before making a transaction, I have to say, when you consult a client, then it may qualify as advice and you are no longer conducting portfolio management. That would mean that you have to apply for a license if you are a portfolio manager in order to conduct investment advice. I'm not fully with the AFM. I do not fully agree with the interpretation of the AFM. I always find it difficult when a local supervisory authority publish such kind of guidance because you need to take into account the European level playing field, of course. So it's really up to ESMA in order to tell something about the interpretation of the definition of portfolio management or asset management. From a legal point of view, I would say what really matters is that in the two things. First of all, in the contract between the portfolio manager and the client, it has to be stipulated that the client may not instruct the portfolio manager to conduct certain transactions at the request of the client. That's the first condition. The second condition is that consulting with your client does not qualify you as an investment advisor. But what really it's all about is whether at the end of the day you as an investment firm make the decision whether or not you have consulted your client. And if the latter is the case, then it still qualifies as portfolio management. But the AFM seems to have a slightly different interpretation, which in practice means that you can qualify as an investment advisor, although you think to act as a portfolio manager. The MiFID II quick fix, which is more or less are some amendments to the MiFID II. What are the most important amendments? First of all, sustainability, of course, which is the main issue perhaps for this year. And one of the major changes relates to product governance. Product governance, regulation of product governance is not new. We all have, I assume, that in place. But you have to include in your product governance process that you take into account the sustainability preferences of your target market. That is, of course, important, but it is also quite severe because it will not broaden the target market, but because if you have to take into account those preferences, it will smaller the target market because clients or that have the same financial preferences, the same risk profile from a financial point of view or from an investment point of view, may have very different preferences if it comes down to sustainability. But you need to include that in your product governance, and perhaps you may want to change or amend the products you are distributing to your clients. That also relates not only to manufacturers but also to distributors. So whether or not you are the issuer of the financial instruments or when you are an asset manager, in both cases you need to comply with these new rules under the MiFID II fixed quick fix. Then there's also a few exemptions are being introduced, which is good news for the wholesale segment. Investment firms are exempt to certain requirements, and for instance, when the investment services relate to bonds with no other embedded derivatives than a make-whole clause, or where the financial instruments are marketed or distributed exclusively to eligible country parties. So be aware of those two exemptions. You may in practice decide to continue and still apply product governance rules, even if you can make use of those exemptions because you find it simply useful for yourself. Then another change under this MiFID quick fix is electronic communication. Electronic communication is important nowadays. When I started as a lawyer, it was totally the other way around. The client had to give permission for electronic communication. Now it's totally turned around. So you may make use of electronic communication, but you have to offer your client the possibility to get it on paper. So the information you have to provide to your client is say that you listen, dear client, we are going to communicate electronically, but if you want to have it on paper, please let us know. So it's more an opt-in for the client. Then finally, another important change is the research. The inducement regime with respect to research is quite severe. So for mid and small caps, there is an exemption. That exemption indeed, in essence, enables you to ask a joint payment for the provision of research and the provision of execution-only services. So if you combine those two, you may ask for a joint payment. That is new, and the purpose is that it is important for mid and small cap companies to get access or easier access to the capital markets, and that is the reason why this exemption has been introduced. Well, this was my quick overview of some major changes, some major topics when it comes down to MiFID II. I thank you for watching, and I always say, see you in court. Thank you very much.